give you. Yeah.
9, whoops.
So the answer, of course, on 48 is C. How about 49? In the purchase price and terms section of the residential contract to buy and sell, the entry for cash at closing, remember that's that 4, it has the price of the home, the deposit, the loan amount, and how much the down payment is. It does not include closing costs. Closing costs. And how do we figure closing costs? How do we figure closing costs? If the loan amount is less
3%?
than 3, then if the closing cost, if the loan amount is less than 180,000, the estimated
Is 3.5.
the estimated closing cost is going to be about 3.5%. If the loan amount is over 180,000, it's going to be about 3%. Remember that, guys. That's a good rule to use. So the answer is B, boy. It only includes their down payment. It doesn't include their closing costs. You
Cash
have
at
to-
closing is down payment?
Pardon me?
Cash at closing is the down payment?
The cash at closing in that box only gives you their down payment. It doesn't break down their closing costs. Where are they going to find out what their closing cost actually is?
At the,
They're going to go take a loan application. What are they going to get within 3 days after the loan application? They're going to get a GFE, which is a
good faith estimate.
good faith estimate. And they're also supposed to get a TILA. What the heck's a TILA? Truth in Lending, TILA, Truth in Lending Act report. But now they've combined them together and it's called a TRID, T-R-I-D, just to really mess us up, okay? So we get what? A good faith estimate and a TILA report, but now they're combined and it's called a TRID, T-R-I-D. Don't need to know what that stands for, just remember that's what it is. Okay. Let's go to number 50. Some properties may be subject to property taxes from a special taxing district. We've talked about that. They put in a sidewalk, pave your street, whatever, serving a defined area or special. And if the buyer determines that the property is within a special taxing district, now this is a special taxing district. This isn't a special tax. We talked about the special tax. But a special taxing district is the story I told you about North Glen when they first became a city. And their sewer and water didn't work. So they not only had to fix it, but they had to buy all their water from Westminster and Thornton. And it wasn't unusual for your water bill to be higher than your house payment. That's called a special taxing district. And yes, you still see them out there. You see them mainly in Douglas County and Weld County, but not necessarily. You can see them anywhere. Water's a huge issue. So the answer is, they can terminate the contract by written disclosure to the seller. I find out an hour before closing it's in a special taxing district, I can cancel the whole deal. Where are you going to find out if it's in a special taxing district? In the title policy. In the title policy, guys.
So it's A?
So the answer is A. Answer is A. All right, let's go ahead and break. Let's do it. Number 51. In the Colorado exclusive right to buy contract, who is ultimately responsible for
Paying the commission?
paying the commission? Who is ultimately responsible in an exclusive right to sell buyer's agency? The buyer is ultimately responsible. Who pays it? The listing broker. But if for some reason he does something where we don't receive the commission, he or she is ultimately responsible. The buyer is ultimately responsible. You will have that question, guys. Don't miss it. Don't miss it. Any questions on that? Okay. So the answer is B, boy. 52, unless otherwise agreed, the Colorado Commission approved exclusive right to sell listing contract gives the broker the right to, and this is a weak question, everything we need permission in that contract to do. Collect deposits from the buyer. We can't do that with, it has to be in the contract, everything's in the contract.
We can choose B.
And the answer is B-boy. That's it, put a lockbox up, put a sign up, collect the earnest money, all of that we cannot do without the seller's permission. And, on that whole long thing there, the answer is B. B-boy. And 54, Colorado Real Estate Commission approved listing forms provide for, 53 is B-boy.
Oh, wait.
I'm not gonna read that whole stupid thing. You have to read that 4 or 5 times to understand it, and if you did do that, the answer is B-boy. And 54, Colorado Real Estate Commission approved listing forms provide for what? A, the broker to disclose any adverse material facts about the property. Everything he knows or should have known. So, A, 55, a tenancy at will may be terminated. Remember, that's where you have a friend of yours staying in the basement.
D.
How can it end?
C. D.
Destruction of the properties, death of the parties,
Yeah, D.
sale of the property unless other arrangements are made, or the 3-day notice of termination. Those are the 4 ways it can end, so the answer is D, dog. All of those. Which one's missing? We have what? Death of the party, sale of the property, 3-day eviction,
Destruction.
or destruction of the property. Write that down, destruction of the property. That's another one. Everybody understand what a tenancy at will is? You have a friend of yours staying in your basement, you're probably not gonna have a lease, are you?
I have like 3-day highlighted so much in my notes that I just thought that was the answer.
See, that's why they do this,
Yeah.
to get you. Don't let them get you. Don't let them get you, guys. Expect to see this one again, and you'll see the other one too, what Tanya just said, the one we have a 3-day notice of eviction. You will have that one for sure. 56, the inspection provision of the contract to buy and sell allows the buyer to terminate the contract.
C.
C, if the property is unsatisfactory in the buyer's subjective discretion for any reason or no reason. C. 57, according to Colorado Real Estate Commission approved exclusive right to sell listing contract, transaction broker, the broker shall disclose which of the following? We just talked about it. B, boy, any adverse material information about the property actually known by the broker, and also everything that he should have known. '58. The Colorado Real Estate Commission approved definition of working relationship transaction broker does not contain which of the following provisions? Notice the longest one.
B.
Broker will be the buyer's exclusive agent for purposes of representing the buyer to acquire interest in the property. The definition of working relationship does not contain that. What does it contain? If the buyer agrees to conduct all negotiations through me, yes. We talked about that in the contract. What else? How about B? The broker will make a reasonable effort to locate the property. And again, broker shall disclose to any prospective seller all adverse material facts actually known by me. So B, boy. I spent time on that, guys. You're going to see it again. We don't talk about that definition of working relationships a lot in this course. It's a real obscure form, but nonetheless you have to have it on every one of your deals. 58, no, let's see. We got 58, 59. 58 is B, boy. 59, a Colorado real estate licensee is not required to maintain a written brokerage relationship if the office policy is, yeah, I have that if the scratched out for some reason. Let's see, is, okay. You do not have, to maintain a written office policy. You as associate brokers do not have an office policy manual. Only your employing broker does. Only the firm does. That's what they're getting at. Yeah, I for C. Yeah, everybody got that? You're in the employment of another broker when you're an associate broker. 60. When a non-resident broker receives an earnest money deposit, it must be held. Remember, this out is on the state exam exactly like this. And a bank recognizes depository. And that's wrong. It doesn't have to be a bank, but that's the right answer. You will see it on the exam. I've seen it the last 5 years, guys. You're going to see it. So look for that bank. That's your tip-off. It's the right answer, even though it's wrong. Okay? It's wrong, but just a little wrong. 61, the contract to buy and sell states that time is of the essence. What's that mean? It means these dates are strictly enforced. So D-Dog. Dates and deadlines are strictly enforced. If you miss a deadline, you can't come back to it. 62. What is the purpose of the Colorado Real Estate Commission Rule F? How many times have we had this? A whole bunch, right? Did I hear B? A, to what? Protect the public by helping to enforce the Colorado Supreme Court decision of Conway Bogue. There you go. That's all you need to see. You think you're going to have this on the exam? How many times do we have it on this test? You're going to see that sucker. 63. In advertising a property for sale or rent, a broker associate in Colorado must disclose. Actually, C, both the broker's associates and the employing broker's license name and phone number. You have to have the name of your company and their phone number, then your name and your phone number. So the answer again is C. 65. Which of the following may not, the N-word, may not adopt a trade name? Let's go with 65, see if you're paying attention. What'd you get? 65. Which of the following may not adopt a trade name? What's a trade name? That's RE/MAX, Century 21, ERA, something like that, Keller Williams. And of course, an associate broker will not have a trade name. Only the firm, the company, will have a trade name. So who cannot have one?
Brokers.
D-Dog. D-Dog, the broker associate, associate broker.
What was 64?
We're heading there. Okay.
Heading back, like.
What disclosure is required when a buyer's agent approaches a for sale by owner on behalf of a buyer? We have to have, this is a weak question. They love it on the exam. We have to disclose how we're working with our clients. You know, I have this lady, I have this guy, I have this couple. What is that called? A single party listing. Remember that? I'm going to show it to a single party. And that single party listing may never have, very good, a holdover clause. Guys, remember that one. You're going to have that one. Don't miss it. That's an easy one. Remember that. Everybody understand what a single party listing is? I'm going to take that whole listing to show it to a single party. I can never have a holdover clause. How are we doing? Make sense?
64.
And 64 is C. 65 is D. 66 in Colorado. Who gets a copy of the contract to buy and sell? Everybody who signs it. It's going to be all of those, all of the above. You see one like this, and it's so easy, you think it can't be that easy, and you blow it. Yeah, every now and then they throw you a bone. Make sure you take it. Don't blow it. You'll have several questions on the state exam. You're going to go, well, that's just too easy. Good. Good. 67. 66 is D-Dog. The developer of a condo conversion into 20 residential units, I'm thinking what? Has to be registered with the Real Estate Commission. And what if it's a condo? How did it become a condo? Probably from a party wall, which is also known as a pertinent easement. So that's what's going through my mind. okay? Then I look at the answers. Notify existing tenants that the conversion will terminate their leases? No. Register with the Colorado Real Estate Commission, there it is. Member condos, co-ops, or timeshares, 20 or more units. Has to be registered with the Real Estate Commission before development can start. $68, which of the following requires the use of the licensee buyout addendum to the contract to buy and sell? Remember that word. If I'll list you over for 3 months. If I don't sell it, I'll buy it. That is an, look at that word, inducement. Inducement. Look for that word, inducement. That's also known as an option listing. Look for that word, inducement, which means incentive. So C, 69, in Colorado, when your real estate license is inactive and you are selling your own home, you must D-Dog. No disclosure is required if you're inactive. You're still a broker.
You have to disclose in the contract or separate writing.
You bet, you're still a broker. B-boy, guys, not D. B-boy. Even though you're on inactive status, you're still a broker. B-boy. 70. A broker may use the escrow funds before closing. Remember, who typically holds it? The listing broker. Who can hold it or who may hold it? Anybody at the direction of the parties, at the direction of the beneficiaries. You could hear them call both of those. And yeah, you're going to see this one again too. Everybody got that? As directed by the beneficiaries of the escrow. And who are they? That's the buyer and seller, right? They're the parties to the contract. It could be the parties, the direction of the parties. 71, a salesperson has earned a commission on the sale sorry guys. A salesperson has earned a commission on the sale of a listing that was originated and sold during her engagement with broker R. How can she get paid? Kind of beating this one to death a little bit because you're going to see it. The answer is A. Broker R must pay her direct, even though she's with another broker. You don't pay her through the new broker, you pay her directly. Okay. 72. Items added to the Colorado Real Estate Commission approved contract to buy and sell real estate. Computerized word processor contract must be, if we produce, or what do we do? What do we put in the lines? It has to be in differentiated print. It has to look different than the rest of the contract. Differentiated print. C. 73. An applicant for a Colorado real estate license who has been licensed in another state must file with the Colorado application. Remember, I really highlighted that when we saw it in the manual. A certificate of licensing history. They want to know if your license was suspended or revoked or something. Licensing history. C. 74. A broker associate who is licensed with a broker who uses a trade name is licensed under, you're not licensed under Century 21 or RE/MAX. You're licensed under your individual broker's name. You're licensed underneath your name. Not RE/MAX or any of those other, you're not licensed under your employing broker. You're licensed under your own name. Now, it could be co-licensed under your employing broker's name. That could be another answer to this. It could be. Not only your name, but your employing broker also.
So it's B.
So again, individual broker's name. Yes, B-boy. 74. 75. If a salesperson collects security deposits, and of course, I'm thinking this is an outdated question. We don't have salespeople anymore, right? What we do? When do we have salespeople?
It's inactive.
If you're inactive, then you're considered a salesperson. Other than that, you're a broker. You're a broker. If a salesperson collects security deposits on a property for an owner, where should that money be paid to? And of course, to your security deposit. I like this one. I like this one. What do you think, guys? How about B?
B.
To your escrow account, right? That would be correct. If C wasn't there, I like this one. Really tricky. It's what a security deposit. So B is correct, but C is more correct. Your broker's security deposit trust account, because it's a security deposit. Isn't that cool? I like that question.
But
What if we
wouldn't-
circled both?
But
We
wouldn't-
circled both, you missed it.
For Colorado, wouldn't A be more correct than B, even though neither of them was correct to C, because we're brokers, not salespersons?
Where should the money be paid to? The broker's escrow account? That's correct. B, the salesperson's escrow account? No, B is correct. C, the salesperson doesn't have an escrow account. So I was wrong, guys. B is not correct, no matter what. You as an associate broker will never have an escrow account. Only your employing broker. So A, it should be the employing broker's escrow account. Would be correct if C wasn't there. And it's more correct, it's the actual security account. Your security deposit account.
That's
As
what they're
opposed to-
implying in this, in this question, the salesperson is the associate broker and the broker is the
That's just
employee broker?
it. That's just it. The associate, they're saying salespeople, they mean associate broker, is what they mean by that, okay? So, how about 76? So C's the answer to 75. 76, when can a broker's license be revoked or suspended for the legal acts of such a broker's salespeople? B, boy, when the broker fails to reasonably supervise the salespeople. And and that's wrong. We don't have salespeople unless your license is inactive. Like I say, there's questions that are wrong. Some are really wrong, some just a little wrong. This one's just a little wrong. You're not going to blow this question because it's a little off. You're going to get it. Who would not, the N word, who would not be required to be licensed to sell property for a fee in the state of Colorado? Remember I told the story about I put a property into an escrow account for my granddaughter? I'm the what? I'm the trustor. I set up the trust. Who's my granddaughter? The beneficiary. And then I appoint my daughter to be the trustee. Because I'll be long gone when my granddaughter hits 21. So I'm the trustor, my granddaughter's the beneficiary, my daughter is the trustee. And she does not have to be licensed to transfer property in a trust. Any questions on that one? Now, in real life, they have to be licensed. They changed it a year and a half ago, but it's still like this on the state exam. So, sorry guys, well, I can't apologize, it's not my test. We didn't make up these, well, we did make up these questions actually, we just haven't updated them. We haven't had a committee meeting in 6 years to change any of these questions. So,
Do you think that you'll have one soon to change them?
we'll have it not during your tenure, so you'll be fine, you'll be fine.
I feel like this is something that should be pretty regularly updated, though.
I would think,
Yeah.
It's a lot of work, it's a lot of work. We spent an entire week, all day long, going over these. And it's a tremendous amount of work. Okay, anyway. So this is the right answer. You're gonna have it on state exam, like this. The trustee doesn't have to be licensed, even though in real life he does, or she does, either one. Okay, 78. A Colorado broker wants to split a commission with an out-of-state broker. This is acceptable as long as the broker's licensed in the other state, which is true, but it's half true. They also have to have a place of business in that other state. Right? But this is okay. This is still right. It's a little wrong. It's a half truth. I tell the story about that time when I was in Tucson and I went to a new home subdivision and the guy asked me, I told him I was from Denver and he said, I got a buddy moving there, you want to sell him a house? I said, sure. He said, would you pay a co-op fee? I asked him if he was licensed, and he was licensed in Arizona, And he did have a place of business, the new home subdivision. So I was able to pay him a co-op fee. Any questions about that? Everybody gonna be okay when you see that?
There are states that don't require a specific state test, like if you're nationally licensed nationally.
Do what now? I'm sorry.
Like if you're licensed in Colorado, is there any states that you can just go and sell, or do you have to be licensed in every state?
That's a good question. We can be licensed in all 50 states if we want to be. But yes, you have to be licensed in that state to sell real estate in that state. But I tell the story that I had a guy from, a broker from Idaho one time calling me up. And he said, does Colorado have reciprocity with Idaho? I said, I don't know, call up Idaho, don't call me. I said, what's going on? He said, well, I got a broker here and all her family lives in Idaho, and she wants to go up there on the weekends and sell property to her family. I said, really? That'd be terrible. Your family's not great to work with in this business, guys. They want you to work harder on their deal than any other deal you have, and they want you to do it for free. Pretty much. That's family, okay? And I said, instead of doing that, call up a broker up there and tell them you'll pay them a referral fee, or they'll pay you a referral fee. And you get whatever you can work out, 25, 30%. I mean, I just saved her a whole lot of grief. You know, now she has a broker up there doing all of her work. She's going to get paid thousands of dollars for that one phone call to work with her family up there.
So if I
So,
have
yeah.
a friend in Colorado that wants to buy in Texas, I would give the
Be able
broker
to
out there.
call a Texas
Oh yeah, a friend in
broker.
Colorado who wants to buy in Texas. Do you have one?
She
Do
wants
ya?
to get a winter property.
You betcha. Go down. I'll tell you what. Go underneath my license, Tina, and we'll do that. And we'll split the commission. Okay, so I can work with them on it, make sure everything's cool. If you want to do that, we can do it now. So that'll pay for this class a couple times over. Just a referral fee like that. So
Cause you still have to have.
what's that? Yeah,
That's how he's helping you out on that.
you bet. Yeah. Anybody else in that situation? Come talk to me. So I love working referrals. That's some real gravy money. You literally make thousands for a phone call. So don't ignore that. Okay, where the heck are we?
79.
Well, I think I missed it. What was the answer to 78?
78 is D-Dog. You have to be licensed in another state, but you also have to have a place of business in that other state. This is correct. It's only half correct. Okay, so 79. In a transaction with a listing broker and a buyer's agent broker, who typically holds the earnest money? The listing broker or anybody at the direction of the parties or the direction of the beneficiaries. 80. The owner of an apartment instructs the broker that she will not sell her apartment to a member of any minority group. The broker bringing, get rid of that offer there, bringing the offer, it should be to the owner, or just be offers, plural, to the owner. Again, must present all offers. Must present all offers. And she will not sell her apartment to a member of a minority group. You know, if they tell me that, you know what I'm going to do? I'm not going to take that listing. They're not my kind of people. And I'll tell you what, when you take a listing and you're working with a buyer, guys, you better like these people. You're going to be living with them for the next 5-6 months. You better like them. And if they tell me something like this, or what if they say some off-color joke, some about a minority or something? That's all I need to know. They're not my kind of people. I'm out of there. Your call whether you want to work with them or not. But like I say, you're going to be living with them for 6 months. Yeah.
So at what point would that become violation of fair housing?
You know, is it our call? We can report them, of course. You know, and can we report them? Only the aggrieved person can report them.
Oh.
So they make an off-color joke about some type of anything to do with fair housing. I can go report them, but they're not going to do anything. It has to be the aggrieved person. So I can go find that aggrieved person, somebody who they, you know, the whatever, and have them go do it. I can tell them this guy said that, but it's his word against mine then too. So again, when you're talking about fair housing issues, you have to be really, really careful. But again, they're really strict as far as the reporting and everything goes too. They want to make sure they have a real ironclad case when they go after somebody. Okay, so 80 is D-Dog. 81, what shows all deposits and payments to and from a broker's escrow account in chronological order? The journal. The journal. What's another answer for that? All of the ledger cards. What's another answer for that? All of the bank reconciliation statements.
Is account journal the same thing as the journal, or would the answer?
No, the answer is account journal is the right answer. But all of the bank reconciliation statements would also work. All of the ledger cards would work also. And you're going to have that question too. I think I either have it here or on the national portion. Where will you not find everything that happened in a transaction in chronological order? You would find it in all of the ledger cards. You would find it in the journal and all of the bank reconciliation statements. You would not find it in the closing statement. That's one you're going to see on the state exam. And you're going to see it either here or on the national portion, guys. When we go into closing in a couple days, we cover that pretty heavy. Okay, let's keep rocking here. So 81 is D-Dog. 82, the closing instructions form, and then they have, we don't care about that number. And it was, remember closing instructions, what word do we want to remember? Engage. It engages the closing entity or engages the closing agent. Either one.
Thank you.
So it's D.
So D-Dog on 82. 83. If an earnest money check is not honored, in other words, this earnest money check bounces, what do? The broker should notify the seller and say, what do you want to do? Should we, looks like this guy's a flake, should we go find somebody else? We ask for instructions. How do you want us to handle it? How do you want me to handle this?
So it's all D.
So D-Dog on 83.
So
84, if an employing broker moves his place of business without advising the real estate commission, C, all of the real estate licenses in that brokerage company are inactivated. They have to know where to find us. We can talk about any of these guys, only just machine gun them. Let's discuss them if you want to. Let's go to 85. In Colorado, there must be a specific time of expiration of a written listing contract because of... This is one of the few things that the Real Estate Commission can do. The Real Estate Commission cannot make rules. They cannot make state statutes. Okay, let's talk about this, guys. Let's talk about corporate structure. Some of you, you want to set up your corporations. Hopefully you're thinking about names. And please come see me, and let's get your company set up. It's real important that you understand how a corporation works. You're going to have your minutes, of course. You're going to have your EIC, Employment Identification, EIN number, Employee Identification number. You're going to have all of these things, and you're also going to have your business plan. What's the purpose of your business? And remember, in a corporate structure, you've got your leaders and your managers. What the difference is a leader establishes company policy. They set the status quo. The managers enforce the status quo. A leader sets the status quo, a manager enforces the status quo. I'm telling you that because that's what the Real Estate Commission does. They're not the leaders, they're merely following the state statutes and their board of directors when it comes to this kind of stuff. And that's how a corporation works also, guys. I'm a one-person shop. Boy, I tell you what, that's tough. That's a tough road to hoe. You can't, how many hats can you put on and still be credible? You're going to make friends in this class. You're going to have the rest of your career. Go into business with them. Have part of your business plan that you can get rid of them anytime you want to. If you want to, you can do that too. Remember, I told you also, it's so important also that you make what your plan is for making money. Remember, you cannot write off the tuition to this class unless you have it in your business. Remember when I would talk about taxes, the way I understand it, okay? You cannot write off the tuition to this class unless in your business plan you say part of what your business is education. You can't write off your college tuition unless you set up a corporation and make that part of your business plan. That makes sense? So, again, we'll talk about that when you set up your corporation. Takes literally 10 minutes and $50 and you're there. So I went in the other day, I've got my corporation and I always had DBAs underneath it. You know, doing business as and whatever. They won't let you do that anymore. Cool, I'll just set up separate corporations. No biggie, I just won't have subcorps. They'll just be their own corporations now. That's fine, that didn't bother me a bit. In fact, it's more succinct that way, really. Any questions on that? Let's keep going, where the heck are we? 86?
85.
85, of course, the answer is B, boy. The Real Estate Commission can set this rule. They can't set much of anything, but this is one they can set. 86, if a salesperson terminates their employment with the broker and goes to another broker, again, D-Dog, they can receive it straight from their old broker. It doesn't have to go through their employing broker, D-Dog. What have we had this? 3-4 times in this test? You're going to have one of these. Don't miss it, it's an easy one. 87, when selling options in real estate, what type of license is required? And this one is just a weak question. What kind of broker's license? You're talking about an SEC, stock broker's license, or real estate license? You're selling options in real estate in Colorado. You have to have a real estate broker's license. This is just a poorly written question. But the answer is B, boy. And you will see it again. So, 88, in Colorado, when does a trust account have to be opened by a real estate broker? Whenever we receive money, yeah.
Sorry, going back to 87, so what you're saying is you basically have the selling option as a broker, no matter what.
Well, what it says is, when selling options in real estate, I have a rent with option just to buy your property, and I have it in the contract that I can sell that option. I have to be a real estate broker to be able to sell that option. Or it has to be my contract on the property. Then I can sell it. I can have somebody assume it. But if I'm working with you and someone else has a rent with option on your property and they want me to sell it, I have to have a real estate broker's license. Not an SEC license. It's just not a strong question
So
at all.
Is a real estate option license even a thing?
No, it's a real estate, again,
Or like,
when selling
Is it a-
options in real estate, okay? There's no such thing as a real estate broker's option license, okay? But I can sell any type of real estate I can sell when I get my broker's license. In some states, you have to have a separate license to be a property manager. You have to have a separate license to sell timeshares. Not in Colorado. You can do anything in real estate, period, once you get your broker's license. The only thing you can't do is your community association manager, being a manager of a homeowners association. That's a separate license. But they just came out with that a couple of years ago. Before that, you can do anything in real estate, and you pretty much can now, except for that one thing. And there's only 7 states that require that, and Colorado is one of them. That's why it's so important that you look to do that when you're done with this course. How are we doing with other things that you need when you're done with this course? We talk about it occasionally. Actually, I talk about it probably more than I should. Mainly because you need other income streams. The next license you want to get after this is either your property and casualty insurance license or your mortgage broker's license. or your community association manager's license. But get all three of those after this. Get all three of those. And get other income streams. Yeah.
Of those, which one do you find to be the most lucrative while also trying to start your business?
Out of those, I would say probably the insurance license. Because every home you sell your own insurance on it. That's not a conflict of interest. So it's just a natural progression to get that property and casualty license. Yeah.
So can you do that when you're working for somebody like Keller Williams, when they have their own connection with their own?
Talk to them and see. That's a real good point. Can you do that? Probably not. If you're with Keller Williams. But if you're, or any other company, you usually can. So again, just talk to them. And again, everybody has their own rules and everybody has their own priorities. But that's what makes a horse race. Okay. And then the next one, I would say get your mortgage broker's license. Start doing loans on properties. You might transition over and just be a loan originator. Or do both. Do both of them, especially after you have your license for a couple of years and you can be out on your own. Do your loans, do your insurance, and do your sales. Ka-ching, wow, not bad, not bad, not a bad way to go. And then you get your community association manager's license too. And get a job as a community association manager where you get a free place to live more times than not. You get a good solid salary. And then you have it set up where people in there, you can refer those sales out to other brokers and get a referral fee coming in. Because you have a broker's license, you can do that. Talk to Lauren or myself. Later on, we'll show you how to get that set up when you get to that point. Okay, let's get going. I start talking about that, I get excited. I feel like, let's stop right here and go make some money. You bet. Where the heck are we?
89.
And like I said, I lose track. I start talking about that stuff. How about 89? When an initial contract for sale of a property is used other than the contract approved by the Real Estate Commission, the contract should be prepared by an attorney representing the buyer or seller, or an attorney representing us as a broker. Yeah.
Is that just because they're not using like the regulated forms?
They're using a contract for deed an owner will carry. No, that's not an approved form. And they're complicated. That's a complicated contract many times. You know what used to happen? If I was a seller and I carried back the loan, you know, I made $200,000 on this sale. You know, I could put the money in a savings account at 0.5%, or I could loan it to the people who just bought my home and charge them 8.5% and have the property as security. But you know what sellers used to do? Is they used to have them sign a quitclaim deed. So if they missed a payment, they could just record that quitclaim deed and get them out of the property. You can't do that. You can't do that. Remember, every foreclosure has to be judicial, unless you have it held by the public trustee. I mean, these they have to be followed. And so many times the seller has no clue that he can't do that. So you've got to direct them how to do it and get a real estate attorney. You know, if you're having contracts done for real estate, you can use a regular attorney. Nothing says that they can't draw up your contracts, but they're not real estate attorneys. So keep that in mind. So 89 is D-Dog. 90, activities that require a license by a licensed law and that are performed by a broker associate should be performed in the name of which the following, we just talked about this an hour ago. C, the broker associate and the employing broker's name. Remember on your for sale sign you have the name of your company, then your name's underneath it. Your name's never first. Company name first, then yours. 91, the Colorado Real Estate Commission approved exclusive right to sell listing. Seller agency contract provides for, what do you think? It's an option for the owner to provide a property disclosure form. That's not a mandatory form. It's optional. So B-boy. 82, an employing broker's office must actually have a physical address. You can't have a post office box. Now that's the employing broker. You guys as associate brokers can have an office in your house. You can have Anything, anything. You can have just a post office box, anything. You're an associate broker. So C, and then 93, in Colorado, when a property is sold for unpaid property taxes, the purchaser at the time of purchase receives, remember on the day you get the winning bid, what do you get?
Or certificate.
Certificate of purchase. Certificate of purchase, not a certificate of sale. That's what it's called in other states. In Colorado, certificate of purchase, whether it's a tax sale or a trustee sale.
So when is it a treasurer's deed?
When it's a tax sale. Remember, it's a treasurer's deed, it's a tax deed, but more correct, they could call it a tax deed too. But more correctly, it's a treasurer's deed, because they're the one putting the lien on the property.
93C, right?
93 is C. 94. A statutory period of redemption on a residential property in Colorado is? Remember, the period before the sale is your what? Equitable period. Then after the sale is your statutory period. And we don't have statutory periods after the sale anymore in Colorado.
So D.
So D, Doc.
Can you explain that a little bit? Like, what exactly is the equitable period and the statutory period?
Remember that? Were you here the other day when we went over foreclosures?
No.
I don't think you were. So.
And I'm trying to watch the videos online. I think that's one that I still have to watch.
Yeah, you probably still do. We did that just a couple sessions ago.
Okay.
I think that's lesson 8. Yeah, I say lesson 8. 7 or 8, one of those two. Anyway, but we go over foreclosures very heavily. We spend a lot of time on them. And your period before the sale is called your equitable period of redemption. Then it's sold. Then you have a statutory period of redemption after it's sold. But in Colorado, we did away with the statutory period in January 1st, 2008. We don't have a statutory period anymore. We only have an equitable period, which is how much for an agricultural property. You guys remember? Agricultural.
115 is residential.
Haven't heard it yet. Haven't heard it yet. 215 to 230. 215 days to 230 days for an agricultural property. What's the other kind of property? Non-agricultural. And how much is it for that? 110 to 125. Let's do this again. Let's do this again. What is the equitable period of redemption for a non-agricultural property?
115, 130.
110 to 125.
110 to 125.
And is that like?
Poor Shannon's going, man, I don't know.
Period of redemption, is that like a period of time in which the person that was being foreclosed on can come back and?
That's right, and redeem his property.
Okay.
Is your equitable period before the sale. And what is this equitable period of redemption for someone with an agricultural property? 215 to 230. Yeah, guys, get those down. Get those down. You're going to have questions on them on the exam.
Terrible.
Plus, you need to know those. You really do. So you can help people and explain to them. Remember, it used to be completely different before January 1st, 2008. And people will think about that. Remember, it used to be, the equitable period used to be 45 days, up to 45 days. Then the statutory period kicked in. And it was 6 months for agricultural properties, 75 days for non-agricultural, and the statutory. All these numbers, guys, all of them. People out there, most people, if they think they know something about foreclosures, think about the way it used to be before 2008.
So
More times than now. That's been my experience with people.
agricultural was 215 to 230?
Yes, and non-agricultural.
110 to 130?
See, it's not single family and farms. It's agricultural and
And
non-agricultural. And so agricultural is 215 to 230, non-agricultural is 110 to 125.
But basically, they kept the times all the same. They
Pretty
just
much
kinda
the same
combined it.
amount, it's just they made it all equitable period. Before, there was only 45 days of equitable, where you got caught up, paid some late fees, and you were cool. And then the statutory period kicked in, we had to pay off everything.
So they just moved the statutory period up, basically.
Kind of combined the two, yeah. Anyway, that's how to play the game, and yes, you know, to knowing these foreclosures, you need to know them. There'll be several questions on the state exam about that, but guys, you gotta know this for real life. People are gonna expect you to know this. This market is up and down, it's gonna change. We're gonna have another foreclosure market someday. Okay, let's hope it's not real soon, but we will. We will. And in the meantime, you're still gonna be working with people who are gonna be going through foreclosure. There's still foreclosures out there. And be able to work with the people. That's a good market, guys, selling these people's home before they go through foreclosure. Almost everybody has equity anymore. Not like it used to be, where you're upside down. Okay. Where the heck are we?
95.
95, here we go. A change in the prior appropriation water rights from a less agricultural use to a higher residential use may be accomplished by condemnation. Condemnation.
You condemn the lesser.
You condemn the senior use and put the lesser one up there in its place. What? Okay, the other three ways of condemnation, we talked about this a few hours ago. What's that? Blighted building, eminent domain, inverse condemnation. One more time. Water usage, eminent domain, inverse condemnation, and a blighted building. Okay. Okay. So, 93 is C. 94, a statutory period of redemption on residential property in Colorado is, again, no longer required. D-Dog, numbers 95, a change. Oh, we already got those. We already got that. How about 96? In Colorado, the maximum time a lessor could hold a security deposit is 1 month after termination of lease or specified by the lease, no longer than 1 month or 60 days. Anybody looking at that and saying, I can get my deposit? Any of you think about going after your landlords after we talked about this? Really? Nobody's thinking about going after them?
I think
Okay.
everybody was till Tony kinda chimed in.
What'd Tony say?
You said if you
That if it was in the
sign the lease,
contract.
agreeing to it, then
Yeah, the contract
agreed to it.
overhails the statute.
No, that statute is for an illegal purpose. Tony and I have to have a chat. It's good. We're gonna have a beer in a couple.
Confusing.
Yeah.
We're gonna have a couple. We're gonna have a
Maybe
beer in
feel
a couple
better
days. A
about
couple
myself
things I
and
want to talk to you about. So that's one of them.
Even
No, if you sign that contract.
Your job is.
So if you sign a contract where you
It's a
agree
little
that you
harsh on
will.
that.
Okay, let's put it in context. You sign a contract on a listing and you agree that you will not sell this home no matter what to anybody having to do with fair housing. That you sign that contract so it's binding. No, it isn't. It's for an illegal purpose. And because of that, it is void to begin with. And that's how it is if you sign one for one of these things. Where they make you clean the carpet and make you clean your, no. It's normal wear and tear, and that's a state statute. It can't be changed except by the state. The landlord can't change it. That makes sense?
It did until 20.
So Tony came along. Well, you know, Tony and I'll have a chat about that. You know, it might take 2 or 3 beers, I don't know. But anyway,
But how is that an illegal purpose if they're saying, you're gonna have to clean the carpets, you're going to have to do this? So how is that an illegal purpose? They're just saying what they
Because the law
want.
says you can't say that.
because you take that property subject to normal wear and tear. That's state statute. What's normal wear and
Why are they
tear?
allowed to put that in the lease?
What's that?
Why are they allowed to put that in the lease?
Because they don't know any better, and the tenants don't know any better either, and they sign it.
Isn't it just
I
like
would
an
love to be a part
HOA
of that
rules?
conversation.
What's that?
I would love to be a part of that conversation.
I should get Tony in here, we'll discuss it.
We should, it'd be great.
So if you were renting
Oh, I'll
a
make
place
time.
and that was
When
in
you
the
weren't here.
contract, you're saying that you wouldn't sign it, or you would say like, I'm not.
I would
we're
say-
rewriting
Where
this
would you
contract.
find
I
a
would,
place to
I
live
would
in
bring the
Denver?
manual,
You
I would
didn't
bring the
find
manual and say, folks, look at this. You cannot do this. Every contract you have out there can be broken by the people and they can sue you for getting them in a contract for an illegal purpose.
But do you know millions of people live here in Denver? Sign this
Everybody
contract?
nationwide. They
Yeah.
don't know. The landlord doesn't know that they're doing something wrong.
But it's scary that attorneys don't know, judges don't know, landlords don't know,
They
owners
don't,
don't know.
guys.
I mean,
They don't.
You
I
know.
can't tell you how
what's the
many,
purpose of the purple book?
guys, I can't
Jim
tell you how
knows.
many calls I get from attorneys. And how many calls I get from judges. You know, it's flattering, but at the same time, come on. This is basic stuff. This is stuff if you're a real estate broker, you should know this like the back of your hand. And every lease out there says that you have to bring it in the same condition as when you bought it, or when you got the lease. Every lease says that. And you sign it because you don't know any better. And then you bring it back in the same condition it was, and they still knock you $200-300 because they have to go in and clean it up better.
I've never heard of anyone getting a security deposit back.
It's very rare, very rare, very rare that you do.
I've always gotten mine back, and I understand there are not good people in
But
this
a
world.
lot of people have done everything they could and then some. And then they still end up getting screwed around. So guys, you know the laws now. I'm glad you mentioned that about Tony. But Tony and I are buddies, you know. But see, Tony has this idea also about opinions. Did he go into that?
He said that you and him agree on 90%. The other 10% is okay that you
So there's
guys
that
don't.
10%.
Well, he said,
Yeah,
he
this is
said,
the 10%.
we have our opinions. An opinion is never right or
Yeah,
wrong, it's just an
highlighted for you.
opinion. And that's all opinion is, it can never be right or wrong. And I said, really? I said, in my opinion, I think that your opinion on opinions is wrong, but that's just my opinion. Opinions can be right. Okay, we're gonna have a couple, more, 2 beers, it looks like. Let's keep going. Let's keep going.
Daiquiris at the Red Lobster.
There we go. Where the heck are we now? I'm totally
97.
lost. 97. Jay withholds a portion of a renter's deposit with good cause, but again, fails to notify the tenant of the reason which the following is correct. He'll lose the right to any of the deposit. Remember, if he only, how about all this stuff too? This is state statute also, guys. Within that time, he keeps a portion of it and doesn't tell you why he kept that portion, you get it all back. And this is slam dunk in court. Slam dunk. And what if it's the whole, what are the terms? Remember? 1 month or 60 days. And the whole term goes by and you haven't heard anything from the landlord, then you get back your deposit plus 3 times the amount.
Oh, that's if you don't get any of it back and don't hear.
Yes, and he
Okay.
doesn't say
So
anything.
wouldn't the answer be B then? He may be liable for triple the total?
No, because let's read the question again. He withholds a portion of the
Oh.
deposit and doesn't say why he kept the other portion. He has to give it all back.
And triple the total, it's talking about Jay, not talking about the tenant, so he wouldn't receive triple, the tenant would receive triple.
The tenant, yes, the tenant, if the whole time went by. And we have that one coming up too. Okay, guys, so 98. What the heck's an NED?
Notice of election,
What triggers an NED?
getting behind on your payments.
Acceleration clause?
Acceleration clause. And what triggers an acceleration clause?
Being behind.
Behind on your payments. Let's do it again. So you get behind on your payments, what does that trigger?
Acceleration clause.
An acceleration clause. What's an acceleration clause trigger?
NED.
NED, what's that trigger?
Foreclosure.
There you go.
What does NED
Good.
stand for?
Notice of election and demand. Notice of election and demand. We spent a lot of time on that in class, so it's really good you get that stuff down, guys. Okay. So, an NED in a Colorado farm, I like this question. An NED in a Colorado farm was executed July 1st, 2008. It was sold in a foreclosure on March 1st, 2009, on which the following dates to the owner's equitable period of redemption end.
March 1st,
The day it was
2009.
sold. Yeah, that's your equitable period, the time before the sale, right? So, B-boy. Good question. 99. The entire unpaid, what the heck's ad valorem mean?
According to value.
According to value, ad valorem taxes on a Colorado farm become delinquent on June 16th. How about residential property? June 16th. How about commercial? June 16th. All delinquent taxes become, all unpaid taxes become delinquent on June 16th. They're trying to get you guys with this stuff. On a Colorado farm, on a residential and commercial, it doesn't matter. They're all the same, all the same. So it's D-Dog. The doctrine of water rights, which is accepted in Colorado, is doctrine of prior appropriation, which means first in time, first in right. And what states have that? With limited water. They have limited water supplies. Doctrine of prior appropriation, first in time is first in right. Where else do we see first in time is first in right? Recording deeds or liens. First in time is first in right. It shows priority of repayment. Who's lost on what I just said? Remember recording those. The data recording establishes the priority of repayment in case of default or sale. Okay.
101.
So B-boy, 100 is B-boy. 101, unless expressly reserved in the instrument of conveyance, all except which of the following are included with the title to the land in Colorado?
Water rights?
Tributary water rights. Remember, they have to be transferred with their own deed. They have their own legal description in Colorado. We're very unique in that way. 102, in Colorado, when must a broker deposit earnest money in the broker's trust account? D? No. How about C? Yeah. No later than third business day after notification of acceptance. Any questions on that? How about we're coming up to this next one. How about a property manager? 5 business days from receipt. Regular broker, 3 business days from notification of acceptance. Any question about that? Guys, you guys will be employing brokers someday. You're gonna have to know when to get that money in your escrow account. Plus you need it for the state exam. 103. An owner of 35-acre parcel of undeveloped land may drill a well for water. I'm thinking, remember the Senate Bill 35, you have to have a minimum of 35 acres? That doesn't guarantee you can get a well permit. But may drill a well for water only, B-boy, after obtaining a well permit from the state engineer. You can't just automatically go drill a well because you have 35 or 40 acres. Who's lost on what we're talking about, Senate Bill 35?
So what,
Yeah.
didn't you say there's something where you have like automatic rights to the water if you're
No.
over a certain amount?
If you've got minimum 35 acres and it was subdivided after June of 1972, you have a right to get a well permit, but you don't have a guarantee. Not at all, not at all. Okay, any questions on that? And again, that's Senate Bill 35. 104, which contract does not, the N-word, fall within the purview of Commission Rule F? Which one's D-Dog? A deed. Yeah, a deed. How are we doing with that list? Should we do it again or just move on? Yes, no? Let's do it. Tell me. You started. We have this one, of course, a deeds. Deeds, there's no approved deeds. Installment land contracts, owner will carry contract for deed, land contract, installment land contract, all the same thing. What's another one?
Leases.
Construction contracts. Business opportunities.
Leases.
Leases. Developers, what's that called? New homes with warranties. All of those are forms that are not approved by the Real Estate Commission. Okay. So, 104 is D-Dog. 105, which of the following is true regarding the statement of policy concerning Rule F? Can we add anything to the contract? Yes, we can. We can add things to the contract and have them attached to the contract. So they may be added outside the body of the approved form. 106, Commission Rule F does not include We're gonna have, you're gonna have 2 or 3 of these crazy ones about the ones they don't include, the ones they do include. So get those down pretty well, guys. We spent quite a bit of time on that today for a reason. Don't miss those, and you're gonna have them on your finals too. You'll have them down. You should really have them down by the time you take the state. So D-Dog on 106. 107, a licensee buyout addendum must be used when? Look for that word. What word are you looking for? Inducement. There you go, inducement. There it is, C. Offering a purchase as an inducement. I'll list your home for 3 months. If I don't sell it, I'll buy it. That's an incentive. That's an inducement to get you to list with me.
Stressful one.
I'm sorry.
A stressful one.
A stressful one?
Yeah.
Stressful promise, you better believe it, yeah. 108, a broker may list a property currently listed with another broker when the new listing begins after the current listing ends. Yes, A. And 109, in the Colorado Supreme Court decision in the Conway Bogue versus the Denver Bar Association, which of the following is correct? A, real estate brokers were, what's enjoined mean?
Stopped.
Were we stopped from the practice of law?
No.
We were not stopped. That's what Conway Bogue was all about. So it's not A. It's C. If a broker encounters legal problems, we should seek an attorney's advice. 110, when a real estate broker completes the inclusions, exclusion provisions of the residential contract to buy and sell, items like water, soft security, remember those squares in that contract? You're going to have this one again. What's it mean? C, they're usually rented or leased. The buyer has to go renegotiate those leases. Everybody cool? 111. In terms of the residential contract to buy and sell real estate, the buyer who intends to borrow the funds to pay for the property is actually A and B are both equally correct in this one. You're not going to have both these on the same question. I just combined these together. I could have made 2 separate questions, but I thought, why not just keep them? Okay? Both of those are equally correct. They're required to obtain a loan commitment in writing and will be released from the contract if the same is not obtained if you can't get a loan, and obliged to inform the seller in writing that the loan condition has been accepted before the loan condition deadline, and attach a copy. 112. In terms of the residential contract to buy and sell real estate, there are strict time limits within which the borrower may review sorry guys, give me a second here. In which the seller may review title documents. Title documents. County records? No. The seller's credit report? Not hardly. Any appraisal obtained by the seller or lender? No. No. Remember, as brokers, we never see the appraisal. The buyers never see the appraisal. The sellers never see the appraisal. It just magically appears at the closing, and they shove it in with all the rest of the paperwork because people don't know how to read it. It's very, very involved. You're going to say something?
I was wondering about that because I've seen people, like you go to appraise a house, they'll be there, and they'll be like, I had this appraisal from so long ago, here's this, that I figured it might help you, so I wasn't understanding about how they wouldn't get it because I know that they've had it before. So they just get it at closing then, they never see it before they get the house.
You never see it before closing. Now sometimes, now you're supposed to see all of the financing stuff 3 days before closing. But the appraisal isn't necessarily one of the things they see. The lender typically keeps it from the buyer because the buyer doesn't know how to read it. All the buyer cares about, did it come in? That's all I care about if I'm a buyer. I don't want to know the details.
And then also with appraisals, with seeing the actual form, when do they see the form they're financing? When do they receive the form?
Very good. When did they receive the forms telling them remember we have down payment, what's the other biggie? Closing costs. When do we know those figures? Within 3 days after loan application. We've got that. Now that's still kind of it's better than our estimate. Remember, we just did 3.5% under 180,000 or 3% over 180,000. We're high on that, hopefully. Almost always we're gonna be high on that. We don't wanna be low on that. But that's very rough. Now, 3 days after loan app, they get something that's very, very close. And then within 3 days before closing, they get the exact figures so that they can see them before closing. That's how it's supposed to be. 3 days before closing. This came into effect October 3rd of 2015. Every closing I've had, nobody's had their figures 3 days before closing, and they close it anyway. So, they're not supposed to, but they do. Don't know what else to tell you. Where the heck are we now? 113, here we go. Rule E3 requires that a broker leaving the employ of an owners association must, remember I made a big point out of this, those documents belong to the homeowners association. You don't give them to the new broker coming in, you give them back to the homeowners association because that's who they belong to. Right. In the residential contract to buy and sell real estate, the buyer may request review of common interest community governing documents and may give written notice to the seller of any unsatisfactory provision and terminate the contract. And again, I made a note for, the answer is D-Dog, guys. And I don't know what the heck happened here. Jenny, I don't know what Jennifer was thinking. But anyway, I just put down the original answer is right, okay? And again, may give written notice to the seller of any unsatisfactory and terminate the contract at any time prior to the reception of those common interest community documents. And I make those the same date as the title, is what I do, the title policy, both the same date.
Wait, what?
So anyway, we don't have the answer here, guys, but that's when it is.
C113.
Okay. What's that?
C113.
So
Yeah,
what is
there
the
we go.
answer?
Well, 113.
C113, we say C113.
What would the
What's
answer
the
have?
And the answer again is, buyer may request review of the common interest community governing documents at any time prior to the date that we put down that they can receive those. If they haven't got them and you're close to that date, you want to get an amend extend and extend out those dates.
So it's really E, none of the above.
Yeah, it's about it, it's E, that's right. Okay, guys, so 115, the Real Estate Commission must investigate any written complaint. A, like I say, you go here your whole career and not get a complaint. If you do, it doesn't mean you did anything wrong. Answer it. 116, a broker has developed a website advertising the broker's office. What, if anything, does the broker need to include? This is a really outdated question. This came about when the website was first introduced. I remember when this question came about. And the answer is, there's no need for any additional disclosures. A very weak question. But it's like on every state test, it's like the first question that came out after the internet was invented. By Al Gore. Remember that? Pretty wild. Anyway, I don't want to go there. 116, a broker has developed a web. Oh, we got that one. There's no need for anything else. How about 117? And appurtenance is D-Dog, something of value that passed with the property, but it's not a part of the property, it's next to adjoining or adjunctive. D-Dog. 118, the seller listed his house for sale with the broker on February 1st. The listing agreement was to last 5 months. In April, the seller decided that the house was no longer for sale. Which of the following statements is or are true? How about B, boy, the seller has withdrawn the broker's authority to sell the property, but that listing is still in effect without a termination letter. So the answer is B, boy. Write down termination letter in there somewhere. 119. Several weeks after a closing, an associate broker received a thank you letter from a nice bonus check from the seller of a house. The associate broker cashed this check because he felt it was earned. In this situation, which of the following is true? I'm not crazy about this question, but the answer is D-Dog. It's a violation of commission rules to accept this. But I had my broker's permission. That's not enough. you have to run that through your employing broker. All money you receive has to be run through your employing broker. Anything you receive, which has to do with working underneath his license, has to be run through him. Any questions on that?
What were you, can you just clarify, I guess the difference between that scenario and any other where you receive like a referral?
Okay, let's talk about this. So I'm sitting at the closing table, and one of the people, the guy, will hand the guide broker $100. If it's a woman broker, the woman hands her the $100. That's just proper protocol. And so that seller hands me a $100 bill and says, "Thanks for the great job you did. Here's a little extra for you." What does a broker do? They put it in their pocket and walk out of there. They're supposed to run it through their employing broker. Everything we receive has to be run through our employing broker. No broker does that really, but you're supposed to. Now, what can you receive? You can receive referral fees from people who aren't part of the transaction, like roofers, paint people, anybody working on the outside of the house in any way, working on the yard, all of those people you can get a referral fee from, but nobody who's part of the transaction.
And you were supposed to run those as well through the
Yes,
employing broker?
thank you, and even those you have to run through your employing broker, and you have to get permission from both parties to receive them. Boy, do everything right, guys, do everything right. The laws aren't that tough to obey, they're really not. They're really not. And I think I've told you what I do. If I have a broker who comes up to me and says, "At the closing today, the guy gave me an extra $100, here it is. Run it through my account." You know what I do? That tells me a whole lot about that broker. I'll match it. I'll give him an extra $100. You kidding me? That is one honest broker. And I'll match it for him. Now, if that happens every deal, I'm gonna get a little suspicious. But outside of that, if he's, I mean, that is about as honest as you can get, because I would never know about it if he didn't tell me, would I? So, okay. So D dog on number 119, not a great question, but that is the correct answer. 120, may a broker accept a referral fee from a title insurance company? Never from a title company, ever, ever from a title company. An associate broker wants to purchase a property for investments. The property is not listed with any broker. The associate broker must, D-dog, disclose to the seller that he or she has a license and inform their broker of the transaction. Even though it's my own property, my employing broker has to know about everything I do in real estate. 122, a listing agent receives two similar offers to purchase and sets an appointment with the seller to present the offers. Another offer comes in from an associate in the same company. In this situation, the licensee should present A, all three offers for simultaneous review. 123, the tax certificate is used to show C, the amount of taxes based on county records, on the assessed value. 124, a real estate broker has identified a property that's ideal for a fast food outlet. They ask 4 friends to contribute money to gain partial ownership interest. The broker will manage the property and negotiate the lease for the fast food company. In this situation, the broker, remember, we have to comply with state and federal securities laws in investing with this investment group. This is kind of an obscure question. You may very well see it again. This is kind of like, has to do, they didn't explain it right. They should have gone one step further and said several properties. Then we'd be talking about a syndication. It would have been a much cleaner question if that were the case, but it isn't, so. 125, real estate practice in Colorado assumes that which type of deed will convey property unless otherwise provided. What's our default provision? A general warranty deed. If we don't say what type of deed, it will default to general warranty deed. Where else do we have default provisions? What if we don't put down how the people are taking title? It will default to tenancy in common, tenancy in common. What else? What other default provision? If we don't say how we're working with someone, it will default to transaction broker, guys. If you missed 32 or less, you passed. Did you pass? How many people passed it?
Is that for your guys' standard or the PCI standard?
Is that the PSI standard, our standard? That's 75%. That's
Missed
75%. What, you missed 36? Those are 36 you won't miss on the state exam, Eric. Congratulations. Take this test until you pass it, and if you need more bubble sheets, let me know. Who passed it today?
I need
Two
more
of you
copies
did.
of the
Two
test
of you
because
did.
I circled the answer on the test.
I was close.
Okay.
I mean, of like the 30 that I did.
Or you could just cover up the answer, Tina. That's another way to do
But
it.
there was
So,
like, you know, 95 more, so. Who knows? Who knows?
Okay.
Yeah, who knows?
very important day to say the least. Any questions, anything you want to talk about? We covered this whole book today. Wouldn't you agree? Pretty much, pretty much. Well, if there are any questions, I will catch you in the morning. No, you need your 3-ring binder for tomorrow.
I think my contract to you